A utility model is an intellectual property right to protect inventions. This right is available in a number of national statutes, as described below. It is very similar to the patent, but usually has a shorter term and less stringent patentability requirements. The German and Austrian utility model is called the Gebrauchsmuster, which influenced some other countries such as Japan. In Indonesia, the utility model is called a petty patent. Definition: a utility model is a statutory monopoly granted for a limited time in exchange for an inventor providing sufficient teaching of his or her invention, to permit a person of ordinary skill in the relevant art to perform the invention. The rights conferred by utility model laws are very similar to those granted by patent laws, but are more suited to what may be considered as incremental inventions. Terms such as petty patent, innovation patent, minor patent, and small patent may also be considered to fall within the definition of utility model. Requirements for grant: most countries having utility model laws require that the invention be new. However, many patent or utility model offices do not conduct substantive examination and merely grant the utility model after checking that utility model applications comply with formalities. Some countries exclude particular subject matter from utility model protection. For example, methods, plants and animals are normally barred from utility model protection. Australia: the law in Australia provides for the grant of a utility model known as an innovation patent. For an innovation patent to be valid, the invention claimed must be novel and involve an innovative step. An invention will lack novelty if it has already been disclosed to the public through prior publication or prior use anywhere in the world. Publication within a grace period of 12 months prior to the filing date of an innovation patent with the consent of the applicant is not considered to form part of the prior art for the assessment of novelty. The innovative step requirement is supposedly a lesser requirement than the inventive step required for a standard patent under Australian law. An invention will involve an innovative step if there are differences between the invention and the prior art that make a substantial contribution to the working of the invention. An innovation patent is granted automatically after a formalities check without substantive examination, however, can only be enforced once it has been certified, which requires a substantive examination. Innovation patents are available to persons outside Australia, but an Australian address for service must be provided. Innovation patent specifications must be prepared by a registered patent attorney unless the application proceeds as a convention application or as a divisional application. Innovation patent applications cannot proceed as national phase of an international patent application, but can proceed as a divisional application from an international patent application that is open to public inspection. Germany: in Germany, a utility model is considered to be new if it does not form part of the state-of-the-art. The state-of-the-art comprises any knowledge made available to the public by means of a written description or by use within Germany before the date relevant for the priority of the application. Description or use within the 6 months preceding the date relevant for the priority of the application shall not be taken into consideration if it is based on the conception of the applicant or his predecessor in title. Italy: in Italy, a utility model is considered to be new if it does not form part of the state-of-the-art. The state-of-the-art comprises any knowledge made available to the public by means of a written or oral disclosure, anywhere in the world, before the filing date of the application or the priority date. The utility model must also involve an inventive step, i.e., machines, devices or items which are claimed in the utility models must be more effective or easier to use than the ones according to prior art. Utility models cannot claim processes or methods At the time of filing the application, a filing fee is due which also covers the maintenance for years 1 to 4. No claim fee is provided. The Italian Patent and Trademark Office does not perform substantive examination of the application in order to assess novelty and inventive step of what is claimed. The examination is limited to formal requirements only. Publication occurs at 18 months from the filing date or the oldest priority date, if any. At the time of filing the application, the applicant may request advance publication, which normally occurs within 90 days. In any case, only bibliographic data are published after 1 month from the filing. Grant generally occurs within 2 years. The validity of an Italian utility model is ascertained by the judge and his/her technical expert during litigation. At the end of the 4th year from the filing of the application, a maintenance fee for the years 5 to 10 falls due. Foreign companies' residents must indicate an address of service in Italy that may correspond to the domicile of a lawyer or, as always occurs, a chartered patent attorney. Japan. In Japan, a utility model is considered to be new if it has not been made available to the public by means of a written description or by use before the date relevant for the priority of the application. Japanese utility models are not subject to substantive examination, but the owner must request 1 or more reports on technical opinion before instituting infringement proceedings. Spain. In Spain, the novelty requirement for obtaining a utility model is a relative, i.e., only public written disclosure of the invention in Spain is prejudicial against the novelty of the invention claimed in the utility model. This is in sharp contrast with Spanish patents for which absolute novelty is required. What constitutes a disclosure of the invention in Spain has been the subject of 2 decisions of the Spanish Supreme Court, in 1996 and 2004. Availability and names. Utility model applications may be prepared and filed at local patent offices in countries where utility model protection is available. The table below is a list of countries having utility model protection under various names as at March 2008. The members of ARIPO are Botswana, Gambia, Ghana, Kenya, Lesotho, Liberia, Malawi, Mozambique, Namibia, Rwanda, Sierra Leone, Somalia, Sudan, Swaziland, Tanzania, Uganda, Zambia and Zimbabwe. The Dutch short-term patent is no longer granted since June 5, 2008. A Malaysian utility innovation cannot be filed directly from a PCT, but it can be interconverted from a national phase patent application. The members of OAPI are Benin, Burkina Faso, Cameroon, Central African Republic, Chad, Comoros, Congo, Côte d'Ivoire, Equatorial Guinea, Gabon, Guinea, Guinea-Bissau, Mali, Mauritania, Niger, Senegal and Togo.